Section 12 of the English Courts of Justice. In England, and indeed in all Europe, after the feudal law was introduced, the kingdom was governed and justice administered in the same manner as by a baron in his jurisdiction. As a steward managed all affairs in the county belonging to the lord, so the Grand Justiciary had the management of all in the kingdom. He appointed sheriffs and other inferior officers. He was himself a great lord, and, by the authority of his office, in every country but England he became as powerful as the king. But Edward I saw the danger and got it prevented. All kinds of law, criminal or civil, were determined by the justiciary or king's court, which always attended the king. Those delays and adjournments in civil suits to which this court always attending the king must have been liable, gave occasion for separating common causes from the king's court, and fixing for them at Westminster a court of common pleas. Criminal causes have always a more speedy determination. One would indeed think that when a person's life is at stake, the debate should be longer than in any other case, but resentment is roused in these cases and precipitates to punish. It is a matter of no moment to the spectator how a trifling matter of cash be determined, but it is by no means so in criminal cases. When common pleas were taken away, the criminal and fiscal powers were connected, and the power and authority of the great justiciary little diminished. Afterwards Edward I divided the business of the justiciary into three different courts, viz., the Court of King's Bench, the Court of Exchequer, the Court of Common Pleas. In the last all civil suits were tried, in the first all criminal ones, and to it lay the appeal from the Court of Common Pleas. It was called King's Bench, because the king then frequently sat upon it, though this cannot now be done, as it is improper that the king should judge of breaches of the king's peace. The Court of Exchequer judged in all affairs between the king and his subjects, the debts due by either of them to the other, and whatever regarded the revenue. The Court of Chancery was originally no court at all. The chancellor was no more than a keeper of briefs or writs according to which justice was done. What gave occasion to the keeping of these briefs shall now be considered. Edward I abolished the power of the Grand Justiciary. He employed mean persons to be judges, generally clergymen. As the decision depended on such persons, their jurisdictions would be exercised very precariously, and accordingly we find that both in criminal and civil cases they interposed with hesitation, in the former as mediators, and in the latter as arbitrators, and accordingly they would be unwilling to give justice in those cases where they had no precedent from the Court of Justiciary. On this account all the briefs by which the Court of Justiciary determined were kept. To keep these seems to have been originally the office of Chancellor. If a person had a lawsuit he went to the Clerk of the Court of Chancery, who examined the briefs, and if he found one that comprehended your case, justice was done accordingly. But if one could not be found, you could not have justice. Thus we find that the Chancellor was not a judge originally. In Scotland the office of the English Chancellor is lodged in the Court of Session. In England a brief was sent from the Chancellor to the Sheriff by which he was obliged to appear before the King's judges. Judges then, from the irregularity and inaccuracy of their proceedings, gave great jealousy to the King, and on this account many severe sentences went out against them. £10,000 has at one time been levied from the judges on account of corruption. They were therefore tied down strictly to the Chancery briefs, and always bound by their records in such a manner that they could not be in the least amended, not so much as a word wrong spelled rectified. This precision still remains in some cases where not taken away by the statutes of amendment, a mere orthographical blunder, though evidently so, has in many cases made the whole of no effect. The judges were therefore tied down to the precise words of the brief, or if there was a statute, to the words of it. This was the origin and jurisdiction of the Court of Chancery. During the improvement of the law of England there arose rivalships among the several courts. We shall therefore show how each of them began to extend its power and encroach on the privileges of another, and how the Court of Chancery increased its influence. The Court of King's Bench, which judged criminal causes and every breach of the king's peace, was the first that assumed immediately, and previously to an appeal, to judge in civil causes, and to encroach on the jurisdiction of the Court of Common Pleas, by what is called a writ of error, that is, they supposed the person to be guilty of a trespass. For example, when a man owed £IO, and did not come to pay it at the time appointed, an order went out from the King's Bench to examine and find him out, supposing that he intended to conceal himself, and they punished him for this trespass. At present an action on contract can come immediately before the King's Bench. In this manner it was that this court extended its power, and, being supreme over all, none could encroach upon it. The Court of Exchequer brought in civil causes to be tried immediately by them in the following manner. Suppose a man owed a sum of money to the king, which it is the business of the court to take care of, and the man cannot pay unless his debtors first pay him. The court took upon them to sue this other man by what is called the quo minus, that is, by what he is rendered less able to pay the king. As the debts of the king were many, And as the profits of the judges arose from sentence money, which was more or less according to the business of the court, they eagerly grasped at this extension of their power. All the courts endeavored, by the speediness of their determinations and accuracy of their proceedings, to encourage prosecutors to come before them. In what manner the Chancellor came to attain his equitable jurisdiction shall be taken notice of in the next place. After the improvement of arts and commerce, which gave occasion to many lawsuits unheard of before, people suffered a great deal by the imperfections of law. Edward III found that there were a great many injuries to which no brief nor court statute extended, and therefore the Parliament allowed that if a person applied to the Clerk of Chancery and found there was no brief that could give him any remedy, the clerk should look for some briefs of a similar nature and out of them compose a new one by which the complainer might have redress. In this manner the Chancery prescribed rules to the other courts, but as they appointed the briefs and manner of proceeding, this was putting an end to the affair, for there was no occasion to go to any other court, and the Chancery got these affairs into its own hands. There could be no appeal brought from the courts of King's Bench or of Common Pleas to that of Chancery, but they applied to it for what the common law could not redress. The Chancellor in this manner obtained the power of judging in all cases of equity, and is applied to in the greater part of civil cases, the chief of which are, first, the specific performance of contracts. By the common law, if a person was bound by contract to deliver a piece of ground, and afterwards refused to do it, he was only obliged to pay damages, but not to perform it specifically. The Chancery, which was now considered as a court of conscience, enjoined the specific performance of it. Secondly, the Chancery gave redress for all incests and frauds in trust when the common law could not. As the leaving lands to the Church deprived the king of the emoluments arising from them, an act was passed against it. The clergy ordered that they should be left to certain persons who would dispose of them for the benefit of the Church, and if they did not perform it, then, as it was a fraud in trust, the Chancellor allowed the bishop to see it done. In like manner, when persons in the state of affairs at that time were obliged to alienate their estates to persons that had no concern in them, the Chancellor caused them to be restored. Wills, legacies, and things of this sort also fell under the equitable decision of the Chancellor. It will be proper when we are treating of courts to inquire into the origin of juries. In the beginning of the allodial government, when the several courts had arrived at a very small degree of improvement, and before they had experience to examine thoroughly into matters, when any person was brought before them on an action depending on his oath, he was obliged to bring 12 compurgators to swear that the oath was just. There are remains of this at present in actions of debt, where, if the person can bring in a certain number of persons to swear that his oath is just, he gains the suit. It is to be observed that the imperfection of this way of trying was one of the great causes that gave origin to the judicial combat. A nobleman, or indeed any man of spirit, who was eluded of his right by a set of perjured fellows, would rather choose to combat it in the field and appeal to the judgment of God than leave his cause to them. Henry II first instituted that the sheriff and a certain number of persons who had opportunity to be best acquainted with the crime should have the whole affair laid before them, and that the person should be judged by their sentence. The law of England, always the friend of liberty, deserves praise in no instance more than in the careful provision of impartial juries. They who are chosen must be near the place where the crime was committed that they may have an opportunity of being acquainted with it. A great part of the jury may be laid aside by the panel. He can lay aside 30 of their number, and he can challenge them either per capita, that is, any single juryman, or any number of them, if he suspect the sheriff of partiality. There may be many small causes for suspicion of partiality, and of the relevancy of these the court is judge. Nothing can be a greater security for life, liberty, and property than this institution. The judges are men of integrity, quite independent, holding their offices for life but are tied down by the law. The jurymen are your neighbors who are to judge of a fact upon which your life depends. They too can be laid aside for several reasons. The laws of England with regard to juries are only defective in one point, in which they differ from the laws of Scotland. In England the whole jury must be unanimous, which renders the office of a juryman a very disagreeable service. A case may appear to you more clear than it does to me, and may really be different from what it appears to either of us, and yet there is a necessity for our agreement, and of consequence a necessity that one of us should swear contrary to our conscience. In criminal causes there is little danger. People are generally disposed to favor innocence and to preserve life. But in civil cases people are not so much troubled. They are not so much disposed to favor, and many of them are exceedingly doubtful. People of fashion are not fond of meddling in a jury attended with such inconveniences, and therefore, only the meaner sort of people attend the judge. A great man would not choose to be so often called and returned, and perhaps treated in such a manner as no gentleman would choose to be. In this case the law providing for security has done too much. In this country, where unanimity is not required, the service is not so disagreeable. Though a person differ from the majority, he may stand by his opinion and is not forced to comply. And there, people of the highest rank are willing to be jurors. In the actions which come before the Court of Chancery no jury is required, and the Court of Session in Scotland has taken them away in civil causes. Besides the courts that have been mentioned, there were several others erected by the King's patent. Henry VIII erected 3. The Court of High Commission, which sat upon ecclesiastics, the Court of Star Chamber, which takes in anything less than death, and the Court of Wardship, which took care of the King's interest in these emoluments. This last was taken away by Charles II, who accepted a sum for the whole. It is now understood that the King cannot erect a court without consent of Parliament. In no other country of Europe is the law so accurate as in England, because it has not been of so long standing. The Parliament of Paris was only erected about the time of Henry VIII of England. The British Parliament consists of a great number of men, and these of great dignity. All new courts disdain to follow the rules that were formerly established. All new courts are a great evil, because their power at first is not precisely determined, and therefore their decisions must be loose and inaccurate. Thus we have considered the origin of government: 1. Among a nation of savages; 2. Among a nation of shepherds; 3. The government of small clans with chieftains; the manner in which aristocracies arose; the fall of little republics, conquering or defensive; and, lastly, the different forms of government that arose in Europe after the dissolution of arbitrary government.